What are dispute resolution options under the IDEA? Now, in our legal system, which is still largely based on English common law, the initial presumption, called inferred immunity, is that you can't sue the king, which is the government, without the king's permission. So in most of the areas within your child's local school that the government school does, you don't have the right nor the ability to sue the king. You can go to a school board meeting, you can complain, you can protest, or even run for a school board position, but you simply can't sue the governmental king anytime you want or whenever you feel like it. You must be given permission to do so, and there are a lot of different forms of permission that exist under a myriad of different legal theories in our country, including our Constitution and Bill of Rights. But what about under the IDEA and/or Section 504? Yes, under both, a parent is given specific right to legally challenge the governmental king. In the IDEA, these are known as dispute resolution options, to where you have the right and the ability to advocate for your child and secure corrective action. Now, due to the different layers within special education law, there are degrees of disagreement and error on an IEP team and how those errors, mistakes, and disagreements impact our children. So there isn't just one way to address these problems. For more minor issues, mistakes, and disagreements, you have the right to reconvene the IEP team. You have the right to request a facilitated IEP meeting through your State Department of Education, to where they will provide a neutral and knowledgeable intermediary to assist in guiding positive dispute resolution discussions on your IEP team to bring the team to agreement and consensus. Now, you also have the right to request mediation through your State Department of Education, where the state must provide a neutral mediator and no charge to the parties that will work between both the parent and the school district to identify solutions and corrective action in the form of a mediation agreement. This is legally binding. You also have the right to submit a state complaint with your State Department of Education that explains the mistakes and errors that your local school have made when it comes to not following the rules, the regulations, and procedures of the IDEA. Now, a state complaint is not an appropriate option if you are asserting that your child wasn't provided a free, appropriate public education and that your child regressed or educationally was harmed. That is not what a state complaint is for. It is focused more on dealing with procedure. The final dispute resolution option you have is that of the due process complaint. This is submitted to your State Department of Education or indicated state agency, where they will assign a neutral and impartial hearing officer that has been specially trained in the special education laws and procedures and regulations to hear testimony, review and consider submitted evidence, and make a ruling on whether your child was denied a free, appropriate public education or not. You have the stated right under the IDEA to act as your child's attorney, to where you present your child's case, you question witnesses, and make the argument that FAPE wasn't provided and why. So, enforcement under the IDEA rests on you, the parent, and not the federal and state government. Review all of the AU videos in the dispute resolution section to learn more.